Good afternoon, everyone. I'm going to just wait about 2 more minutes to let folks join.
Come on in.
So I sent that out to her. You're in a position to get our response done by Friday or get an extension.
Yeah, I'll try to get next day.
Hello, everyone. Welcome to this much anticipated OADC webinar entitled A Moody Update, the Supreme Court Decision. My name is Megan Cook. I'm a shareholder at Bullivant Hauser and am currently serving as the Secretary Treasurer on the OADC Executive Committee, and I am pleased to be moderating the presentation today. I'm happy to introduce our presenters today, my fellow shareholders, Bryce Adam and Jackie Mitchson. Bryce was recently elected as a shareholder at Bullivant, so big props to Bryce. Round of applause. Welcome. He represents multinational insurer clients, primarily in a first-party setting in our coverage group. Jackie is also a shareholder in our coverage group. Bryce is serving as vice chair of our coverage group and has hit the ground running with that position. He wrote the lovely release to our listserv just days after the Moody decision came out, jumped right on that. And obviously jumped on this presentation. So we're very grateful for his efforts and support of OADC. Quick fact about Bryce. Today he has 2 pugs sleeping within 3 feet of him during the presentation. I'm a little disappointed we can't see him. And Jackie is serving as a co-articles editor for our verdict. Very noble position, and we appreciate her work on our publication. Her quick fact for the day is that she managed to keep, and this is no small feat, 4 out of 4 chickens alive during the recent ice storm. Congratulations, Jackie. So with that, I'd like to get started. A few housekeeping matters. Your microphones and video are muted for the webinar. If you'd like to ask a question, please enter it into the chat section and I will help the presenters monitor the chat section during the presentation today. We'll try to get as many questions answered in the limited time available. OADC is also applying for CLE credits. We're recording the presentation and it will be made available at a later date. It can be found on OADC's website. So if folks that were unable to watch it today, that will be available. So with that, Jackie, Bryce, the presentation floor is yours.
Good morning, everybody. So the way we're going to be doing, or good lunch, everybody, I should say. The way we have proposed doing this is, as you'll see, we have a brief roadmap here. And the way we're going to be dividing this up is essentially into 3 parts. First of all, I'll be discussing the Moody ruling itself and some of the historical context that came before it, because this really is a big one. You've got at least 45 years of Oregon insurance law that we need to appreciate at least a little bit longitudinally in order to figure out exactly what Moody might mean. And then from there, we'll chat briefly about the ruling itself for folks that haven't gotten the opportunity to read it or digest it. It's a long one. Then we'll be going into some of the implications that we think this might have, with the caveat that this is so brand new, God only knows exactly what we'll be seeing come down the pipe. And lastly, we're going to try and devote a significant amount of time to either a Q&A or just an open discussion, so that we can try and create something like a gestalt of what people are experiencing now, and hopefully from there, what we can maybe do going forward, to the extent that people have any ideas at the moment. Without further ado, let me just give you a very brief overview of what actually happened in Moody. So Moody itself, we had a case that went before the Oregon Court of Appeal we got a decision from the Oregon Court of Appeal on this life insurance matter in, I believe, late January of 2020. And that was based, as people know now, the underlying issues in Moody, where you had a gentleman who died in a freak gun accident while camping, and his wife then applied for a small amount of life insurance benefits. And because of the presence of marijuana in his system, benefits were denied. This ultimately led to the decedent's wife suing on grounds of negligence per se and seeking emotional distress damages along with standard breach of contract. The insurer won on a motion to dismiss before the trial court on issues of negligence per se and also striking the emotional distress damages. Went up to the Court of Appeal, like I said, when they handed down their ruling in January of 2022, reversing the trial court and saying that there were grounds for negligence per se claims and emotional distress damages were on the table. That got argued before the Oregon Supreme Court on the insurer's appeal in November of 2022, and we've sort of been sitting since then, and people have been making up the law, or rather, excuse me, not making up the law, interpreting the law primarily at the federal bench, we found, until December of 2023, when the Supreme Court came out with its verdict. So we have had Moody to think about for approximately 5 weeks now. And what we know now, after a lot of pieces of information that have been flying back and forth, a lot of things that were quoted in the Court of Appeals verdict, we now know that the Supreme Court of Oregon believes that common law negligence claims for first-party insurance mishandling or alleged mishandling are now all right. Or as we have on the screen there, a plaintiff has pleaded facts sufficient to give rise to a legally cognizable common law negligence claim for emotional distress damages. And the core of this legally cognizable right is the Unfair Claims Settlement Practices Act, which handles insurance coverage in Oregon. And the other corollary there is that, again, we've had about 45 years of Oregon case law saying that this is not how first-party insurance works. Cases called Ferris, typically referred to as that. I believe the Supreme Court refers to it as Ferris 2, and this was a 1978 case in which it was decided that it's been interpreted widely to mean that first-party insurers cannot be sued for negligence claims based on claim handling or based on violations of the Unfair Claims Settlement Practices Act. The Supreme Court disagrees. Although it did not overrule Ferris, it did sort of juke around it and say that you don't need to really address those issues to get at this fact that common law negligence claims are not okay against first-party insurers. Jackie, next slide, please. So to speak about this Ferris claim just in a little bit more detail, don't need much. 1978 case is the second Ferris case involving this fact pattern. And what you have is you have some business owners that were sued by a third party. They sought to get coverage from their insurer, duty to defend, etc. The insurer that apparently knew that coverage was due still denied coverage, denied a duty to defend, and then fast forward a little bit after the insureds had to put on their own lawsuit. The insureds then sued their insurer for breach of contract, and as part of that breach of contract, they sued for emotional distress damages. This is suing on the contract, mind you. And part of what they're arguing is that the Unfair Claims Settlement Practices Act entitles them to peace of mind. And so by denying coverage, the insurer did inflict emotional distress damages upon them. Now, the Oregon Supreme Court, in looking at that, came up with the notion that if you look at the Unfair Claims Settlement Practices Act, it is meant to regulate insurance, but there is not a public policy imperative that the peace of mind of insureds is supposed to be in there. It also does not create a private right of action. And therefore, emotional distress damages were not cognizable for that type of claim, even if the court agreed that the insurer knew it should have provided coverage and simply didn't. And we've got a long line of cases after that, very easy to shepherdize if you have any interest, wherein parties have agreed that it's essentially conventional wisdom that if you were trying to get a first party insurer for denial of coverage benefits, it must sound in contract, and the tort claim essentially won't get you anywhere. And regardless of this ruling and sort of the judicial trend that had gone along with it in Oregon, in this matter of Moody, you had the decedent's wife, the plaintiff, sue on a negligence per se claim, and she was alleging two violations of the Unfair Claims Settlement Practices Act: failure to pay once liability could reasonably be ascertained, and then also failure to conduct a reasonable claim investigation. So, motion to dismiss went forward at the trial court level based on Ferris, and then once the insured's beneficiary appealed to the Oregon Supreme Court in January 2022, the Oregon Supreme Court panel of 3 judges came up with sort of a really strong riposte to the notion of Ferris. And what they said was that no, in fact, the Unfair Claims Settlement Practices Act does create a cause of action in tort, and that's negligence per se, based on the allegation that violating the act does trigger a failure of your duty under a standard for statutory negligence. And so that meant that the Court of Appeals in 2022 opened this door to these first party bad faith claims that we previously hadn't seen. And what they had done is they've put together a negligence per se claim that has some unique elements that we've, as opposed to common law negligence, that we've seen in virtually every lawsuit since then. As you'll see on the left of this slide, it's not worth me reciting them all, but it's different than the standard duty, care, breach, harm that you'd see with a negligence claim. So these get pled, these 4 elements here, but at their core, what they're saying is that if you violate the Unfair Claims Settlement Practices Act, that was your duty. The insured was an individual that should have been protected under the act. The harm to them was foreseeable, and therefore negligence, or at least bad faith tort damages of some sort. And this also meant that despite all of these years of Ferris, the Court of Appeals also put the peace of mind of insureds at stake and said that the Unfair Claims Settlement Practices Act was meant to defend that. And so since peace of mind was now something that was worth talking about in terms of the statutory protections that Oregon provided to first party insureds, the emotional distress damages were very much on the table then. Now, fast forward to the Oregon Supreme Court's decision, which again was argued in November 2022, and then the local courts and the local federal bench had about 14 months in which to work that out by themselves and see kind of how that was interpreted and how it should be applied day to day. In December of 2023, the Oregon Supreme Court finally weighed in on this matter, and they started off, well, generally they upheld what the Court of Appeals said. So big picture, 40 feet in the sky, neon, is that we should expect to see common law negligence claims going forward against first party insureds, or insurers rather, based on the Unfair Claims Settlement Practices Act. To start with, though, there's an important mechanical distinction to make with how the Supreme Court approached the Court of Appeals verdict in Moody, or ruling Moody rather. They said, to start with, they sided with the defendant in that this structure of a negligence per se claim, as it was promulgated by the Court of Appeals, is in some ways sort of overly mechanistic. In fact, what was going on here was that what we need for Oregon negligence is you just need a duty of care, and a statute can be plugged in to provide that duty of care. So as opposed to all of the unique elements on the left part of this slide, in fact, what you had is the Unfair Claims Settlement Practices Act and the, I'd have to make a number here, but I believe about the 15 operative sub-violations one can commit of that. Those individually could just be the duty of care for, duty, breach, cause harm for a common law negligence claim. And again, as the slide says, just shorthand. So moving on from there, you have the you have the Supreme Court kind of grinding through the notion of how this would work day to day, because you'll see throughout the Supreme Court's ruling, they are extremely concerned, and they comment at length on the differences this might appear to present versus what Ferris had come up with 45 years ago and what Oregon attorneys have been working with in their toolkit on both sides of the aisle ever since. So what they said, first of all, was that, okay, what we're dealing with here is we are dealing with the notion that you need to have a legally protected interest that can be infringed upon in order to make this kind of negligence claim happen. And the legally protected interest is the Unfair Claims Settlement Practices Act. There's no longer any question about that in the eyes of the Supreme Court. So a violation alleged of that act, which was meant to, in the Supreme Court's mind, protect every insured in Oregon, is the interest that is breached and that can lead to a negligence claim. In doing this, the Supreme Court didn't attack Ferris or overrule Ferris, but they did say that the way Ferris had addressed the Unfair Claims Settlement Practices Act wasn't really germane to the question here, because in Ferris, what you had was you had an insured that was going after the carrier for allegedly causing them emotional distress damages on breach of contract for violation of the Unfair Claims Settlement Practices Act, because peace of mind was at issue in what was defended with that act. The Supreme Court here said, well, hold on, we're not talking about that contract-based issue here, so we don't need to deal with Ferris. What we're dealing with, in fact, here is whether there is a freestanding common law negligence claim that derives from this, which Ferris, in their mind, doesn't comment upon. So Ferris, not overruled, but sidestepped pretty decisively as far as that goes. Now, moving on from here, what you start getting some of the key elements that are discussed in the Supreme Court ruling in terms of how they say this will be narrowed and not over applied. They say that if there's a legally protected interest that is established for all insureds by the Unfair Claims Settlement Practices Act, then that should narrow in some ways how emotional distress claims work, they believe, and how tort claims in general should work. First of all, they claim that they acknowledge that you can't create a new cause of action whole cloth that would inappropriately, without any warning, put potential tortfeasors on the hook for their activities. But they say that the Unfair Claims Settlement Practices Act should have put insurers on sufficient notice that, in fact, they did owe this extra contractual duty to their insureds. So, in theory, the insureds were not on notice, no due process issues, etc. Additionally, they claim that this was in accordance with public policy, because this is something that, by the way, that we assume or we predict will bedevil folks going forward, is that it is assumed that there's a public policy interest in getting people paid. Now, this is the distinction for life insurance claims. This is all in the context of life insurance, because there's a public policy interest, especially in this case, a widow who needed a breadwinner husband to get the money you need for food, shelter, etc. And so there's a public policy interest in making sure that insurers pay up. They also claim that this is consistent with prior rulings of the Oregon Supreme Court, and that in particular, it would not interfere with the Unfair Claims Settlement Practices Act, because you can still pursue statutory penalties if you're the insurance commissioner in that. And even if that didn't create a private right of action, having a common law negligence claim moving in parallel to the investigatory procedures that are set up by the Act does fulfill the Act's purpose of consumer protection. And importantly, again, back on the table, like the Court of Appeals said, ensuring peace of mind for the insureds. So all in accordance with public policy. And then something that we expect to see, a particular issue that is very squishy and is going to require quite a bit of deliberation, is the question of emotional distress damages being more cognizable and more likely to be awarded based on the proximity or the relationship between the insurer and the insured. And the reason the court goes into such detail on this matter is partially they are very concerned that if they left the ruling without this caveat, what you would have is any parties to a contract attempting to sue one another for breach of contract and then a negligence claim on top of it. So they said, no, 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 this is narrow. This is insurers who have been put on notice of their extra contractual duties via the act. And then on top of that, for something like emotional distress damages, there needs to be a more special relationship. And again, here's where we get tricky because the Supreme Court is only talking about life insurance claims explicitly in the majority of the ruling. They say that a special relationship may exist between the parties when the contract performer and the insurer knows the identity of the insured and knows that the insured is reliant upon the performance of their service, payment of the life insurance policy. And so when you put together that along with the dependence that an individual might in fact have upon receiving those proceeds, particularly in a case like the facts of Moody, where apparently you had a widow that was reliant upon her husband as a breadwinner. Those don't just create a special relationship such that you owe more or less an independent duty of care. That also creates, when you put them all together, objective indicators that there could be emotional distress damages at issue if the insurer violates their standard of care. And so putting all these together, we basically have a simple ruling in that we know that common law negligence claims based on the Unfair Claims Settlement Practices Act to some degree now are cognizable in Oregon. But past that, there are a lot of gray areas. There's a lot of tricky language going into this that my co-presenter is going to walk into now, along with some of the predictions and implications we believe will stem therefrom. Thank you.
Thanks, Bryce. As Bryce indicated, I'm going to go ahead and talk about some of the implications stemming from our newest Supreme Court decision. So first, we have a big rush of policyholder lawyers running to amend their complaints and add a negligence claim instead of the negligence per se claims that we were seeing prior to the Supreme Court decision. So some of the questions that have been coming up in our office, at least, are how do we fight these motions to amend? And I have a few ideas. I don't know that all of them are winners. For one thing, it's important to keep in mind the statute of limitations for torts is 2 years. So, there's been a long time since the Moody decision's been pending. That's something good to keep in mind. Another option that I think might be worth considering is arguing that the amendment is futile if you have a set of facts that is significantly different than those present in Moody. As Bryce talked about a little bit, this was a situation where we had a life insurance policy with a dependent widow and a decedent who was the breadwinner. So those are significantly different facts than, say, a homeowner's claim where something fairly minor was damaged or something like that. This was a situation where she was financially dependent on the husband and the life insurance company didn't pay out benefits under the policy. So those are some ways that you might argue that the amendment is futile. If you thought that you could win a motion to dismiss potentially, then you might want to argue futility in the face of an amendment. The other question that's come up is whether Moody is retroactive or not. So whether there's a good argument in response to a motion to amend that Moody isn't retroactive. I don't think that's the case. There's there's case law that limits when court rulings are retroactive versus forward looking only, and I don't think the factors are met there, so that's probably not a winner. But if you feel like it is, please share with the listserv because we would love to hear about that. And so those are sort of some ways to think about the motions to amend, but the reality is we're going to see these claims going forward and we're gonna have to deal with them. So in that regard, let's talk a little bit about litigating torts in the coverage world. This is something that's very new to me anyway, as a person who's come up just doing all insurance coverage. I haven't really spend a whole lot of time with the torts and the blood and guts and all these emotional feelings. I really just wanted to stick to the contracts and the words, but here we are. So I've spent some time thinking about it and talking with some of my colleagues who do more in the tort arena and have some ideas for you all. One thing that came up on the listserv over the last week or so was what to put in RFPs in response to Moody claims. And for that, I think what you really ought to focus on is just the same types of things you would focus on in any other negligence claim where emotional distress damages are being alleged. So that would be things like the medical records, the psych records, any personal journals or diaries that might describe the person's feelings or troubles during that time frame, any evidence of changes to their daily life, like if they were so depressed or so anguished that they were incapable of working anymore or couldn't engage in their usual activities. Those would be the type of documents you'd be wanting to ask for. The next sort of step that would come up probably in litigating these is having to depose the plaintiff. And I've heard from at least one colleague that during the course of depositions with Moody claims at issue, they are in the habit of asking, did you experience emotional distress from the claims handling? And this person told me that he's had plaintiffs say no, they haven't had any emotional distress. That's great. So just start out with that question and see if maybe you can get off the hook really easily and cleanly. But assuming they say yes, it was super upsetting. I was like crying every day and it was so horrible. Then you're going to have to kind of get into the nitty gritty on what their mental health concerns were arising out of the claims handling. So you want to ask them about what their mental health was like before and after the claims handling, whether they had depression, anxiety, whether they were on meds before versus after, did they have to increase their dose, whether any of their friends or family noticed changes in their mood, behavior, mental status, that kind of thing. You'll also want to explore whether there was any related physical manifestations of their feelings. That's no longer a requirement because we have this exception to the physical impact rule here, but it's good to know sort of the full scope of what these alleged injuries were. And then I think it's also important to explore other possible causes of stress or emotional distress during the time frame. So getting into what else was going on in their life, like if someone passed away or birth of a kid, new job, all those usual typical life stressors you'll want to ask them about. And then finally, I think you're going to want to ask questions to try and distinguish between the event that triggered coverage versus the negligent claims handling allegation. So a lot of times when something that triggers coverage occurs in your life, it's a stressful event. That itself might cause emotional distress, but that's not what the insurer's on the hook for. They're only on the hook for emotional distress caused by their negligent claim handling. So I think of it as asking questions about whether the event itself caused stress versus the claims handling, and then when the stress started. Did the stress start right when the event occurred, or did it happen later when you were dealing with the claims handler? Those kind of questions, so that you can hopefully prove that you can hopefully disprove causation. In other words, potentially try to say that it was the event itself that caused you emotional distress, not the claims handling. So for example, I had a tree fall on my house last year. Having a tree fall on your house is stressful. It caused me emotional distress, but that is separate from any way that the claims handler did things. Like he made phone calls to me, I responded. So I'm stressed out while I'm talking to him, but that's not caused by his claims handling. That's caused by the fact that a tree fell on top of my house over my kid's bedroom, which is clearly distressing. So I think trying to make a distinguishment there is possibly a route to go for. Other things to consider in litigating these cases is whether or not you should send the plaintiff for an IME to have someone evaluate the mental health claims that they're making. You also want to figure out whether you need to retain an expert for trial, again, causation issue. At the end of our presentation, we're planning to have a Q&A and a group discussion. So if anyone else has ideas of things that you should ask in depositions or in RFPs or other litigation strategies going forward, we would love to hear from you. All right, so we're all sort of here wondering, how narrow is this decision? Bryce spent a little bit of time talking about the facts, as well as just sort of what is and isn't going to be available as a negligence claim. I think going forward, trying to distinguish Moody, we're all going to be sort of latching on to the facts of the case. This was a surviving spouse of a deceased breadwinner, and the court pointed out that she was financially dependent on on this man, and that was important to them. It was also important to the court that she was a named beneficiary on the policy, and the insurance company knew who she was. Not sure exactly how we use that to distinguish these facts that she was a named beneficiary, but I think those are important. They also talked about the insurance proceeds in life insurance specifically enable survivors to obtain basic needs such as food and shelter, so that society doesn't have to provide those things for the survivor. One thing that Bryce didn't touch on that I've been kind of wondering how we're going to address going forward is the life insurance policy at issue in Moody was only $3,000. So while I understand the logic and the reasoning of the protection of the need for food and shelter, things like that, with a policy of only $3,000, it's not really clear to me how not getting $3,000 would have been that big of a deal for this person, that it would be that distressing. Had it been a much larger policy, I would see it more as being, yes, she was financially dependent on this life insurance policy and didn't get the benefits and therefore was really suffering figuring out how am I going to pay my mortgage and my bills. But with $3,000, that kind of is a question, and I wonder what plaintiff's attorneys will do with that fact. We are also just sort of wondering how narrow the category of interests that are of significant importance, that's the language that the Supreme Court used, how narrow is that? Like, is a house that was damaged of significant importance? Does it matter how much damage there was? Does it matter whether the house remains habitable or whether it becomes uninhabitable? And if it is uninhabitable, does the fact that ALE is provided make it such that there's not a significant importance on the peace of mind there because you do have somewhere to stay while your house is uninhabitable? So sometimes that happens where you're just having a valuation issue over the cost to repair or replace parts of the dwelling, but the person staying in a hotel or a rental unit. That's one question that's sort of on our minds. And then another question is, how does this apply in the health insurance context when coverage is denied? Does it matter whether it is for something that is life-saving versus something that merely improves your quality of life or is for your own convenience? There's situations, you know, where it would be better if the health insurance company gave you coverage for something, but it's not the type of thing that it's not a life or death. It's just a nice to have kind of thing. The other question that's sort of come up in terms of the scope of the decision is how widely this applies to different types of entities. So here we had a human individual, but I could imagine a set of circumstances where companies are trying to bring a claim, for example, like a very small business, a sole proprietor, or an LLC, or a very small corporation, where the individual basically is the entity. Would that be something that we could see, or would it not? That's all open questions. The next sort of implication that I wanted to cover on this is the attorney fee issue. Anyone who does a bit of coverage litigation probably feels this too. Oftentimes the attorney fees are driving the claim, and it's one of those things where you can't settle a case because of fees. It's very frustrating. But one thing to note is that fees are not available for negligence claims generally under ORS 742.061. I've got the statutory text up here, and the highlighted part is important, or underlined part. So the statute allows for an insured to recover attorney fees upon an action, for an action upon a policy of insurance. So this has come up a couple of different times in the Court of Appeals. We have the Goddard case and we have the Wiltshire case. Goddard was a case where the insured brought a negligence and bad faith claim based on the insurer's failure to settle a wrongful death claim, reasonable settlement. And so the court went through all that decision. There was an attorney fee petition, and the Court of Appeals had to rule on whether attorney fees were available for this negligence and bad faith action. They concluded that attorney fees were not available because it sounded in tort not an action on the policy. So because the claim was a negligence claim rather than a breach of contract claim, no attorney fees were available. They were looking at the Georgetown Realty case, and in that case, there had been both a tort and a breach of contract action, and the Georgetown Realty case said that attorney fees were available. The Goddard case notes that there was nothing in the Georgetown opinion that suggested that the insurer sought apportionment between the breach of contract fees and the negligence fees. So I think for us, the lesson to take away from Goddard is that when we're challenging attorney fee petitions, we're going to want to take the position that the negligence attorney fees are not recoverable while the contract fees are. So the best you can, split those out, argue for apportionment, say that the plaintiff bears the burden of showing what work was done in furtherance of the contract claim versus the tort claim. So things like motions to amend to add Moody claims, attorney fees for that we should be arguing are not recoverable under this statute. The Wiltshire case I cite there briefly, it just basically said the same thing as Goddard. It was a very short decision. And it's just helpful because it's a more recent case that reiterates the same point. So going forward, I think we see a lot of times our mediations are being driven in large part by these attorney fee petitions. And so to the extent you're getting these petitions in connection with mediations, you're going to want to push back on the idea that fees are recoverable for the negligence action. And same thing when we're litigating. If we get to the point of litigating this in the trial court, we're going to want to make the same arguments and cite Goddard and Wiltshire and Georgetown as distinguishing. All right, so the next sort of thing that we're expecting to see here after Moody is effort on the part of the plaintiff's bar to make additional changes to the decision or to enact bad faith legislation altogether. So one aspect of the decision, the Moody decision, that was really interesting is this little note that parties to a contract can define their own duties, suggesting that insurers could get out of having these tort duties apply to them, the common law standard applied to them, by simply just contracting themselves out of it. And that seems like one area ripe for the legislature to say, no, I don't think so. You have to abide by tort duties. I can imagine that happening. And then another change that I think we might see is expanding the factual scenarios that apply to allow for emotional distress damages caused by negligent claim handling. We've talked a lot about the limitations of the decision in terms of the facts that were present. It doesn't explicitly say that it only applies to life insurance, but it talks about the life insurance proceeds so much as being important for certain reasons that I think it's reasonable to argue on our end that it only applies to life insurance. So that might be one area where OTLA tries to get the legislature to open it up to more things, including, I think, possibly third-party cases. Under Georgetown Realty, we already know that under certain circumstances, there is tort action available. I have a quote for you here. It's when an insurer undertakes the defense of an insured, the relationship between them carries with it a standard of care that exists independent of the contract without reference to the specific terms of the contract. So it's a fairly limited tort action available in third-party cases. And so there's an idea that the legislature might want to open that up and allow more negligence actions in the context of third-party cases. So the other area where I see a big, I don't want to call it an opportunity because it's not an opportunity for us, it's an opportunity for the plaintiff's bar, is to have actual bad faith legislation. So the Moody decision, despite the name that we gave our presentation, didn't actually create a bad faith cause of action. It created a common law negligent claims handling cause of action. So it's a little bit distinct from bad faith in that bad faith typically has a different standard of care that's prescribed by the legislature in the statute. It also often allows for double or even treble damages like we see in IFCA in Washington. So that seems like an area where we might see an expansion of the law. And then finally, I threw the word punitive damages on there. We saw on one of the earlier slides a quote from our friend Bob Bonaparte, who's a well-known policyholder lawyer, talking about what damages might be available and the fact that the Moody decision didn't really put any sort of limitation on what types of damages are available. So presumably punitive damages are available already, but I suppose there's always the outside possibility that the legislature sort of lowers the bar for alleging punitive damages, although as it stands now, you have to meet certain criteria and you can't allege it in your complaint unless you get leave of the court to do it after a motion. So for now, we have that sort of limitation. And then the final thought I had on this one is with respect to attorney fees, we just talked about the limitations on those for just breach of contract claims, not for negligence. That's an area where the legislature could open it up and say that the statute allows for fees on any claim against an insurance company, something like that, instead of limiting it to an action upon an insurance policy. So those are probably the areas we'll see movement or attempts at movement. The legislature has a short session this year and it starts on February 5th. So we could be seeing changes very soon. It's only a 35-day session, but I've heard rumblings from folks are saying that there might be some efforts in the legislature to enact a bad faith bill this time. So we'll see what happens there. I'm sure we'll be hearing good updates from our legislative people. We wanted to open it up now to see, like, what are we all seeing? What are you all experiencing? What are the challenges you're facing? Do you have good ideas for us? Do you have questions? One of the benefits, I think, to getting together as a group is hearing each other's experiences and ideas. So we would love to hear from anyone who has anything to share or any questions.
Does look like we have one comment from Eric in the chat. Jackie and Bryce, are you able to see that?
Yeah. So as I understand it, if the question sort of, can you do a covenant judgment with a Moody claim, I have not run into that at all. I don't know exactly how that would work. As Jackie pointed out, though, I feel like that does create an unusual scenario for our standard policyholder attorneys who are motivated in part by these ORS 742-061 fees, because if you were to divide it off like that, I think in theory, the position we're starting from is that would mean that whatever this subdivided Moody claim you got wouldn't be eligible for statutory attorney fees out of the gate. So that might reduce the appetite of plaintiffs' attorneys to even run with something like this. Jackie, what do you think?
I had this come up. The Wiltshire case was actually a case that Ron Clark and I tried together, and then our office handled the appeal, and I wasn't involved in that. But the point of that case from the OTLA folks, and they were very clear with us about why they took the case and why they were pushing it, is that they were trying to get attorney fees to be allowed in those negligence type cases. And in that situation, it was an insured, farmer's insured was in an accident. He killed a child. He refused to cooperate in any way with the investigation. The police report wasn't available to farmers. So there was no way for them really to investigate liability at all. And so they waited until the police report became available before paying out policy limits. Eventually, there was a transfer or an assignment of his rights under the policy to the decedent's family, and they brought a claim against farmers for failure to timely settle. And so what we had there was this man who didn't want to cooperate in the lawsuit, being represented by a plaintiff's lawyer who was actually representing the estate of the decedent. And so there's a bizarre tension there of him not caring at all and not wanting to participate, and then the family, trying to pursue this claim. And we ended up in a situation where we won on the breach of contract and we lost on the negligent failure to settle portion. And so that's how we ended up with the Court of Appeals case about the fees. I don't know if that answered the question. That was a really long story. I'm sorry. I see a written question from Brian Williams that says, how are people handling discovery requests for the claim file and the adjuster's deposition to get the evaluation of the underlying claim? Any trial court rulings yet? I personally haven't come across that issue with any trial court rulings. We always, as a general practice, share the claim file when requested, redacting things obviously that are not discoverable, attorney-client privilege, reserves, those kinds of things. And then the adjuster's deposition, I'm not sure I understand that part of the question. We typically do agree to have the adjuster be deposed. Maybe the question has more to do with like what limitations we might ask. Bryce, do you have any ideas?
As you said, I think that it's standard practice for us to produce redacted versions of the claim file. Something that I think I've seen more recently with this notion of people going for bad faith now is this presumption that if you get it, the underwriting materials, or rather, I'm sorry, the reserve materials, that might be evidence that there was an intention going forward to do bad faith by undervaluing a claim or valuing a claim highly, then lowballing with the actual offer you made. I don't have a ruling on that that's come up recently, though. I think it's our standard practice that we assume that's not discoverable because it's not germane to any claim in a typical breach of contract or negligence lawsuit. But we are arguing a protective order on that in the near future. So depending on the results of that, we might have some more information.
Yeah, with the rise of the Moody negligence claims, I could see how the policyholder lawyers are going to have a better argument for getting at the reserve information for the very reason of arguing that, you know, the reserves were set high and you were lowballing me, or you didn't even reserve this properly, like you say.
And I think that really they're expecting to find some kind of real crazy smoking gun in most of those instances. And I tried to even explain to one of them that, you know, as core logic gets updated or as Xactimate gets updated, your reserve information will change. It's not really reflective of anything. And the notion that it would pin you down to a particular position, it's sort of like the dog chasing the car, right? I don't know what they do if they caught you.
Right, yeah, and you know, there's a lot of different arguments we could make about reserve information. You know, the fact that you're statutorily required to set reserves that are adequate to pay the loss doesn't mean that the loss is valued that high. It's just the amount that you have to keep in case you do need to pay out, things like that. Looks like we have another question from Elizabeth Smith. Isn't it fishing for evidence to support Moody claims? Should they have to have a Moody claim approved first? Oh, I think what Elizabeth's getting at here is if they're asking for documents maybe or depositions, should they have to have a Moody claim in place first before those things happen, before producing the documents or witnesses for depositions? I think, you know, generally yes, asking for items beyond regular UIM discovery. I have to be honest, I don't do a whole lot of UIM, so I'm not sure what regular UIM discovery is, but things like asking for the claim file in a lot of first party cases that involve property damage, like homeowners or commercial losses, we typically do provide the claim file with the things we discussed before redacted. And, you know, those are things that we would produce for just the breach of contract claims. So I don't think it's asking really for anything more than we already would have been producing in a typical case. Bryce, do you have a different point of view on that?
No, I think that if sort of the flip side to this would be trying to do a motion to dismiss on the grounds that you don't have enough basis based on the pled facts, I think an Oregon court would be permissive enough. You really wouldn't get that far anyway. And as far as the fishing expedition aspect of it goes, I feel like based on the discovery rules, you probably get to argue that this could be germane to your claim. I'm not sure, unfortunately, that would get you very far in dealing with a claim that even pled Moody initially, but wasn't very well founded.
Anybody else have questions or any recent experiences you want to share with attempts to amend or depositions or asking for documents, those kind of things? One thing that didn't really come up in the body of the presentation was the idea that we're going to need to start using claims handling experts in our cases. That's something that really has not been an issue for us in Oregon at all with breach of contract. It's just, you know, what did the policy say and what did you do? But now that we're going to have to be litigating negligence and, you know, there's a standard of care and a question of breach, all of those negligency things, we're going to have to consider whether we get claims handling experts to say what the standard of care is and whether the insurer's conduct met that standard. So that's just something to keep in mind. There aren't a whole lot of people who do that work. And so that's something we'll all be looking for probably in the future, is people who can testify for our clients on those issues. Bryce, do you have anything? Okay.
Oh, yeah, something else just really briefly I was going to toss out. This could tie into what we talked about earlier with discovery requests. Something that I am finding surprising, because I have friends that do personal injury and more insurance defense stuff. The notion that we can ask RFPs seeking medical records, mental health records in particular, and that our friends across the aisle, particularly that do the policyholder work, will just say, there are none, and seem to think that that's not problematic. And that could be because they don't uniformly have much experience with these sort of tort claims. It could be because folks on the other side are relying on the notion that these are such subjective things anyway, that you're really just waiting for a jury to hear the blood and guts and tearful monologue of the plaintiff to begin with. But in any event, I think that's something that should probably be thought of, and we don't have a uniform approach to it yet. But when the other side is either bluffing or just doesn't care that they don't have that kind of substantiating information, we'll need to think more about how hard we think we can hit that, especially given how poorly Oregon's motion for summary judgment standard works in the state court. It could look like nothing, but in fact be sort of the strategically ambiguous in a way that helps the policyholder.
Yeah, I think that's a good point. It seems like the type of situation where the fact that the plaintiff says that they were upset or felt depressed or anxious, even though they don't have the expertise to diagnose themselves and didn't seek a diagnosis, could be enough to overcome a Rule 47 motion. And then they get to go in front of the jury and tell their sad story. It doesn't quite seem right, because I don't think average people actually even know how to diagnose those issues, but I don't know. We'll see.
Okay, any other comments or questions from our group? I think I am interested in how this impacts UIM claims. I think it could potentially be a separate webinar, especially for how to negotiate or settle those. So we could consider that. Thank you all for attending. Thank you, Jackie and Bryce. I think we had some record-setting attendance for post-pandemic OADC webinars. We have 61 folks here, so way to go. I think it just shows how valuable OADC is. On that note, while we've got your attention, if you know of anybody that might be interested in becoming an OADC member, reminder that we have first year free. So especially for our newer or younger attorneys, it's a great opportunity to jump into OADC and see everything it has to offer. So that can all be accessed on our website, of course. So thank you again. Enjoy the rest of your day and feel free to use the listserv to help our members learn more about the post-Moody world. Thank you.